Good afternoon, and welcome to Procurement Law for Lobbyists, subtitled Everything You Always Wanted to Know About Public Sector Procurement, but Were Desperately Afraid to Ask. For those brave enough to have joined, I'm really sorry this can't be in person. We live in interesting and difficult times, and if this is the most social thing you do today, we'll do our very best to keep it as concise, conversational, and fun as the subject matter will allow. My name is Andrew House, and I'm a partner here at Fasken and co-leader, along with Marcia Mills, of the firm's National Security Group. I'm extremely pleased to be joined today by Marcia, who is formerly of the Federal Department of Justice and who has worked on, guided, repaired, and done her best to manage many of Canada's largest and most sensitive procurement efforts. In the 3 years since she and I joined Fasken, Marcia has been my go-to authority on all matters related to the intersection between the laws of lobbying and ethics and the rules of public procurement. You should know that we haven't always agreed. She is a procurement law purist, and I'm a lobbying realist, as many of you are. But our discussions have been, to us, fascinating and productive enough that we wanted to share them with you today. Marcia and I will attempt in the next few minutes to lead you through the complex collision of a series of rules, the breach of which can have very severe implications for individuals, corporations, governments, or all of the above. Now, to be clear, the goal is not to teach you the full body of law surrounding lobbying compliance or procurement. Rather, it is to help you do what every first-year law student is taught to do: spot the issues. Not to have all the answers, but to be able to ask the right questions at the right time. And if you leave today simply more aware of procurement law and imbued with a new sense of both the possibilities and pitfalls of lobbying in and around a procurement, we think we'll have done our job. And before we begin, a few quick housekeeping notes. First of all, anonymity. Your attendance today is entirely anonymous to other attendees, and responses to any questions posed will not identify you by name or by circumstance. We know that some of you are facing issues that entail commercial sensitivity, and we'll respect that at all times. Secondly, if you have questions during the webinar, please click the Submit Question button below the video player, type your question into the form, and click Submit. We'll do our best to answer all the questions. In certain cases, if a question tends to reveal your identity or your circumstances, we'll simply respond offline after the fact. Third, tech support. If you require any technical assistance, simply click the tech support link, which is located under the video player. Fourthly, the slides from today's webinar will be sent out to all attendees after the event. And finally, at the end of the webinar, you'll see a survey button to complete. This is a presentation we expect we'll give again and again because procurement, lobbying, and the collision between these two things is a growing issue, not only in our legal practice, but in your day-to-day lives. So your input on this presentation will help us make it better over time. So without further ado, I'd like to dive in, and I'll start by a personal example from my time in government that Marcia and I have talked through, and we think illustrates some of the values at play here and the ways in which lobbying intersects awkwardly with procurement and the rules governing both of those disciplines. I was a chief of staff to the Minister of Public Safety in the years of the Harper government, and in that role, we said to our staff that there were two things that you must, on pain of resignation from your job as a staffer, never do. The first is ask about a criminal investigation. And the second is ask about a procurement, a particular public procurement. I was in the job for 5 years, and as time wore on, I eventually broke both of those rules. I won't get into the criminal investigation side. That's a whole different webinar. But on the procurement side, let me explain briefly what happened. There was a public procurement for the acquisition of global positioning system anklet bracelets, anklets/bracelets to track the movements of inmates who were released at what's called statutory release. This is where you get to 2/3 of a federal sentence and out the door you go. And we learned that the technology would allow something called GPS wander. It meant that a person who was supposed to be under curfew and in their apartment after 8 p.m. was either in the apartment or 500 meters away at the kids' playground. And you can imagine the difference between those two locations in criminal law terms was very significant. And the technology was not delivering the result that we needed. And when this came to my attention, it came to my attention through members of the industry, not within government, but lobbyists, in-house and consultant who came to me and said, this procurement is in crisis. The procurement had been delayed. It had been maligned publicly in the press. Everybody wanted it to work because there was a public safety value at play, but it wasn't working. Marcia, you and I have had a chance to talk about this circumstance, and without answering all of the questions right off the bat, I'd like this example to sort of follow us through this presentation and help inform a discussion that so many people watching really need answers to, which is, how do I handle situations where procurement rules tell me that I cannot speak outside of that procurement, but for reasons of good public policy and even public safety, I feel like I must. And with that, Marcia, I'm going to hand over to you, and we'll advance into the first slide, please.
Thank you, Andrew. Our agenda today, and the example, Andrew, that you've raised is an incredibly good one because it does hit on all of the issues that we're going to be talking about today. So we're talking about the rules for communication before, during, and after procurement and how they tie in with lobbying, which is what Andrew's just raised. Some who don't end up doing a lot of lobbying during procurement, you may be kind of surprised by some of the rules and what I'm going to say about them. Hopefully, though, the discussion, as Andrew said, will be informative. What's most important that I want to bring out during our conversation today is that these ground rules are changing, and they're changing a lot faster than they ever had before, and we're going to talk about why that is. Finally, as Andrew has pointed out with his GPS wandering example, is each situation's unique, but knowing the ground rules is what's going to help you determine whether you should be lobbying, so that you'll know, can you help hinder or harm your client? So today, as the agenda shows, we've just done our introduction. We're going to talk about the basic levels of communication rules in procurement. Then Andrew is going to level set with us on Lobbying 101, so we can do some distinguishing characteristics between consultant lobbyists and in-house lobbyists. Then I'm going to come back on and I'll walk you through the lobbying before, during, and after the procurement. And then we're going to go through part 4, which is kind of, if you get nothing else out of what we've talked about today, here's some essentials. And then we'll open it up to the Q&A. If we could have the first slide, please, Lauren. And the next slide. All right, thank you. So when a government buys goods or services, they're either going to do it competitively, which is open tender. In the federal realm, you'll see it on buy and sell. You'll see it on bid and go. You'll see it on all of the variety of bidding platforms, or a government might do a sole source. In those cases, you may not see the procurement being published because they're doing it specifically with one or two singular entities, but you may see a notice of planned procurement. So that's generally the way public sector is going to buy. Over the years, as a result of a whole bunch of different factors, we've got a robust body of rules that infuses how parties communicate during the procurement process and how you buy goods and services. There's a whole bunch of different arenas and areas where these rules have come from in Canada. So we've got the common law, we've had the courts looking at trade agreements, looking at just the general procurement practices of not just public sector, but also private sector entities. They've talked about the duty of fairness in Canada. That's something that we've got that's a unique concept in procurement law when compared to other countries such as the US. We have a plethora of trade agreements in Canada that impact public sector procurement. We're up to 16 or 17 international agreements. We've got one national agreement in Canada called the Canadian Free Trade Agreement. And plus we've got some regional trade agreements. We've got one for the 4 western provinces. We've got another between Ontario and Quebec. And Ontario itself is actually starting to do its own kind of sub-trade agreements with different states in the US. All of those factors will influence the legal structure of the procurement. And then the way the procuring entities kind of gather all that together and structure the way that they're going to procure is through their own policies and directives. And a lot of times you'll see that policies and directives in the purchasing world are really influenced by common law and trade policy. And then finally, the other place where the rules are found are in the procurement documents themselves. Those rules may be quite similar to the common law or the trade agreement. They may reflect policy and directive, but they also may be unique to that particular procurement. And that's one of the areas that we're seeing a lot of shift in, particularly at the federal level, with regard to what happens when parties are communicating with each other during a procurement. And as I've mentioned and as we've inferred, these policies and directives are becoming more prescriptive, and they matter to your client and when you're lobbying. We can go to the next slide, please. So as I mentioned, trade agreements, they're a game changer, particularly since 2017 when Canada executed the Canadian-European Union trade agreement. And since then, we've also done a similar reflective agreement with the UK after Brexit. Plus, we renegotiated the internal Canadian Free Trade Agreement. So we've had a lot more opening up of procurement in the public sector, particularly in the last 4 years. And I can safely say that you're going to find at any level of the public sector, from federal right down to the municipality, the schools, the universities, the hospitals, all of those entities are likely going to have trade agreement influence when they're buying goods and services, unless they themselves have been exempted, or what they're buying has been exempted, or the financial threshold that brings the trade agreement into operation hasn't been hit. So, for example, if you have a client who's selling to a public entity and the contract's only going to be $20,000, likely it's not going to be covered by a trade agreement because that's such a low financial threshold. Within the trade agreements, though, they have, and trade agreements are supposed to open up trade between countries, reducing barriers. And so one of the commitments the governments make when they execute trade agreements is to say, hey, one of the ways we're going to reduce barriers is me as a government under this trade agreement. I'm going to accept goods and services from those vendors who sell in the countries with whom I've executed a trade agreement, and I'm going to comply with certain rules of fairness, openness, and transparency as I buy goods and services. So the trade agreements bring common rules together, and there's 3 objectives that they're seeking to meet, which are very similar in a lot of ways to public sector objectives. So the first one is accountability and compliance, legislations, regulations, and policies that apply not just to the buyer, but also to the seller. They want to overcome unfair advantage and conflict of interest that might be created during a procurement. That could be something created by the buyer, but as we're going to talk about in a couple of slides, the supplier is also concerned with conflict of interest issues. And of course, mitigating against political interference, either the buyer through lobbying or the supplier through a very senior executive trying to tell the procurement authority how to do their job. Those are kind of the 3 principal rules that you see in trade agreements that are very similar to a lot of public sector policies and directives that are seeking to reduce conflict of interest, unfair advantage, and ensure that the procurement is conducted in a fair and ethical manner. One thing I will note is because of the prescriptive nature of the rules and because governments need to be efficient in the way that they're procuring goods and services, oftentimes, and I know this amongst my public sector clients, governments will apply the trade agreement rules even if they don't have a procurement that's covered by a trade agreement. And that's for the sake of simplicity, and also because, as I said, those trade agreement rules help governments meet their other objectives of accountability, avoiding conflict, and mitigating against political interference. So if we can just hop to the next slide, please. So the outcome, a little mathematical formula here. Common law plus trade agreements, policies, directives, and scrutiny are going to equate to increasingly strict procurement communication rules. These rules are going to tell you how communication should function during a procurement. Who's communicating? To whom are they communicating? When are they communicating, and how are they communicating? And it also, and we'll talk about this in a bit, addresses what happens to that communication. So if there's a communication during a procurement process, what happens to it? Who sees it? Where is it disclosed? Suppliers are required to know these rules. They're required to comply with them. So, ignorance isn't a defense, and we bring that concept up in a couple of spots. It's also not a defense, and this is important to those of you who are lobbyists. If a public office holder has accepted a meeting with you, called you about a procurement, or returned your phone call, it doesn't mean that's a defense to failing to follow the rules of the procurement. And as we note on the slide, sometimes the public office holder will not necessarily be always aware of those rules. So that's when I'm going to stop. And Andrew, I'm going to hand it back to you to bring us to Lobbying 101.
That's great, Marcia. Thanks for walking us through those preliminaries, and we'll actually dive into to lobbying law in the next slide. Here it is. What is consultant lobbying? For most of you on the line who are consultant lobbyists, you know these rules so well, and we're not going to dwell on them for too long. You live and die by them every day. Consultant lobbying occurs when you undertake, which is simply a meeting of the minds and agreement to lobby on someone's behalf to communicate for a registrable purpose. Of course, that has to be supported by the concept of you being paid. For most of you, that's the name of the game. The lobbying commissioner has been clear that lobbying is a reputable, viable industry, provided you play by the rules, and being paid is part of that. To communicate, you have to actually communicate on behalf of your client, and you must communicate to a public office holder. So those are the preliminaries to lobbying. But of course, there are forms of communication that occur with a public office holder that are not lobbying. And in terms of figuring out what is lobbying, you have to be doing all of these things in respect of or in relation to, and here's the list: the development of any legislative proposal, the introduction, passage, or defeat of a bill or resolution, the making or amendment of any regulation, development or amendment of a policy or program. And for many of you, when you're dealing with procurement, you are most likely dealing with a government policy. At least that's the category into which the lobbying commissioner will likely place your activities if you're speaking in relation to a procurement as a consultant lobbyist. The awarding of any grant, contribution, or other financial benefit, the awarding of a contract by or on behalf of Her Majesty and Right of Canada, and finally, the arranging of a meeting between a public office holder and any other person. It's critical to take note, finally, of these last two: the awarding of a contract or the arranging of a meeting. These are conditions for lobbying that are specific to consultant lobbyists. And in just a second, as we flip to the next slide, and we can go ahead and do that, you'll see that as we look at the definition of what is in-house lobbying, it's all the same, except as you get down to those final two criteria, awarding of any contract. When Parliament designed and passed these laws, when the government of the day designed the laws and Parliament passed this law, it was never the intention to prevent companies from selling their goods or individuals from selling their goods to government. And that's why when you're in-house selling your own products or services, if selling those things is strictly all you're doing, that's not lobbying and it need not be registered. And also the arranging of a meeting. If you're an employee, you're arranging a meeting for someone else in your corporation, also not lobbying. So you can see how these two activities in their definitional elements are very, very similar until you get to those last two items. So without dwelling too much on lobbying, because we're not here today to teach you all the ins and outs of lobbying. Fasken does lots of seminars on that topic, but we did want to cover this important ground just to make sure we know what we're looking at in terms of the intersect with procurement. So we can move on from this to the next slide.
Yeah, and thank you, Andrew. And we can just go on, Lauren, to the next slide. And the two elements I'll mention that Andrew noted for in-house lobbyists, the issue of Parliament didn't intend that they were trying to prevent you from being able to sell your wares to public sector entities. That's important in the lobbying context, but it's still, the communication rules still deal with how you go about doing that during the procurement. So for this next part, we're going to look at, as I mentioned earlier, the phases of a procurement process before it begins, when it's underway, and once it's over. So one thing I will note for those of you who are well-versed in lobbying law, obviously the breaching of a communication rule during procurement isn't a statutory offense. It's not a reportable offense, as you might see in lobbying. And as a lobbyist, your issues with respect to personal liability in that regard don't apply to communications during procurement. But the breach of the communication rules can have a profound impact for your clients if they're breached. So when we first look at, in the pre-procurement phase, what I always work with my clients is making sure that they appreciate that it's not just when the RFP hits the street that a procurement has started. Procurements can actually start much earlier than that. And some of the examples that we use are, for example, industry engagement. When a public sector entity may be looking out to industry to say, look, I have these requirements. Can you meet them? I have future requirements. Will you be developing in that regard? So that an industry engagement such as that may still be within the procurement phase. Also, if public entities are issuing letters of interest or requests for information to industry, they may actually form part of the procurement. Even if they're not within the procurement itself, the public sector entity who's receiving information from the public sector with regard to comments on its requirements or its proposed approach still has to maintain a certain degree of appropriateness with regard to the information that they receive and what they do with that information. So again, what you may end up seeing in these scenarios is maybe you're not into a procurement process, but your client may be required to execute a non-disclosure agreement with regard to their attendance at an industry day or with regard to the information that they receive from government when the government is doing a request for information process. So even if it may not be a procurement and you may still be capable of lobbying, and we'll talk about that issue in a moment, there's still the element of the information that your client has received. Is it under a non-disclosure agreement? Can you use that information if the procurement hasn't started and you want to begin to lobby on a particular issue for your client? Also, there is, again, the influence of the trade agreements. And normally you'll see a definition in a trade agreement that will say, a procurement begins when the public sector buyer begins to set up its requirements. I mention this because, again, a lot of times public sector buyers will follow the same procedures with their procurement that they would follow whether they're covered by a trade agreement or not. We can go to the next slide, thanks. So now we're into the procurement phase. And this, we can definitively say, if a tender hits the street, if the public sector entity has released the tender, you're definitely in the procurement phase. The reason why it's important when we talked about in the pre-procurement phase, making sure you know, is there a procurement underway or is the public sector buyer just information gathering in an open forum, is because once, as we said on the deck, once the procurement begins, you have to reevaluate the lobbying activities with your client in light of the associated risks to your client. And that's because the two basic rules when a procurement is in process with regard to communication about that procurement is it comes from the bidder, it's in writing, and it's provided to the contracting authority who's responsible for the procurement. And any questions that are raised with regard to that procurement are from the bidder to the government, and any of the government's responses are generally shared with all the bidders. Those two rules formulate the basis of the integrity of the procurement process. So what they're seeking to do is ensure that all the entities that are bidding on a procurement have all the information that every other bidder has during the procurement, so that everyone has an equal opportunity to assess that information and to consider it in formulating their final bid that's being provided to the procuring entity. Ultimately, the objective is to ensure that procurements are fair, open, and transparent. And part of the way that we ensure that is making sure that communications remain following certain parameters and remain open and shared amongst all bidders. Let's go to the next slide, Lauren, if you wouldn't mind. Here's an example that we brought up for those of you who do any federal work. This is a standard example of a clause during the solicitation period. So this is, at minimum, once the tender has been released up until the time that the contract's awarded. When you're bidding with the federal government, they're definitive, and this is a mandatory requirement. The language must be directed only to the contracting authority, means this is a mandatory requirement. Failure to comply with this, as the language says, may result in the bid being declared non-responsive. So, as I said earlier, this isn't statutorily driven. This is policy and contractually driven, but the impact, if you're communicating about the procurement outside of the procurement information flow and outside of the rules, could fundamentally result in your client's bid being rejected. Every procuring authority will reserve a right within the tender documents to reject bids for this reason. And it's an absolute right, which they can exercise. I can tell you from my time working in justice and from my time since, I have been involved in procurements where we have had to send alert letters to bidders advising them, you need to stop with your lobbying, you need to stop communicating outside of the process, and put them on notice that their bid could be disqualified. We'll go to the next slide, please. So we're going to talk a bit about explaining the concepts I've talked about, which is unfair advantage and conflict of interest. And we're going to raise them up in a couple of slides. But the issue of importance here is that this isn't a static concept. The assessment about unfair advantage or conflict of interest looks at whether it exists now, whether it could exist in the future, and whether it could be perceived to exist. I often call the last element, perceived to exist, the headline in a local or national paper consideration, because the more concerned a procuring entity is going to get with how the situation is looking because of issues such as communication outside of the communication rules for the procurement, the more likely they're going to start leaning towards, I've got a perceived conflict of interest, I've got a perceived unfair advantage, and now I need to deal with it. The other thing to keep in mind is the client doesn't make this determination. It's not a self-judging, do I think I have an unfair advantage? Do I think I have a conflict of interest? The decision is made by the procuring entity. And again, they will reserve that decision right within the procurement documents themselves. Usually they'll seek out advice from legal counsel if they have a concern about either of these. But generally, they're also going to be concerned with the perception issue of reputational risk, because the procurement needs to be fair, open, and transparent. And if there are any factors that are deviating from that requirement, that increases the risk that the activities that your clients participated in that are violating the communication rules may lead to a determination that they've created a conflict of interest or an unfair advantage situation, and they need to be removed from the procurement. Procuring entities can deal with mitigating or resolving these issues, but if they cannot mitigate against it and they can't resolve the conflict or the unfair advantage, again, they'll be pushing towards removing the bidder from the procurement to save the integrity of the procurement. And as I said earlier, this isn't a one-way street. A political actor contacts you or your client with regard to a procurement they're participating in and either wants to give you some information that you might not know or wants to ask you questions about a procurement and what do you think of the process. They can also feed into the issue that your client has to deal with regard to unfair advantage or conflict of interest. We'll switch to the next slide, please. Here's an example. This is a fairly consistent type of description of an unfair advantage or conflict of interest clause that your clients might see. And the points to keep in mind, I've underlined and bolded some of the words, but understand that the definition of conflict of interest, it includes, but it's not limited to, the 3 pivotal points that are in this document. So these aren't just it, but these are the major considerations for conflict of interest. Also know that it's direct or indirect conduct of the bidder, which means the bidder didn't do it, but the bidder got somebody else to do it. So first issue is having access to information that's confidential to the government that nobody else has. So you, through your lobbying efforts, you've picked up information about the actual procurement, some underlying requirements that some of the stakeholders might have for the procurement, and no other bidder has that. Your client takes that information, uses it within the preparation of their bid. That's an issue. Secondly, this is where lobbying is really called out, communicating with any person with a view to influencing preferred treatment in the process. Now, it doesn't say and giving, it says including the giving of the benefit. So the mere fact of communication with somebody with a view to influencing preferred treatment will hit the second point. And the third one, again, comes back to the theme, integrity of the process. Engaging in conduct that compromises or could be seen to compromise the integrity of the process. And as I said, and as we've said all along, this isn't just the activity of your client who's the bidder. This is also lobbying activity that can trigger this particular issue. Now we'll go to the next slide, Lauren, if you wouldn't mind. Okay. So this slide's got a lot of detail on it, and it's a little bit of a takeaway for later. But some of the points I wanted to raise here is sometimes your clients may see, or you may see in your tender if you're the bidder, the concept of unfair advantage or the concept of conflict of interest, or you may see a definition of one or the other that seems to include all of the points that we talked to today, and that's fairly common. So they're not clearly distinguished. For example, there's no statute that specifically identifies unfair advantage or conflict of interest. Again, the procuring entity that's setting up the procurement or that has its own policy and directives in that regard is going to have predefined those particular issues. Again, as I said earlier, if it's in a policy, don't think that that's your only assessment point, because there may be particular definitions and language used in a procurement document which go beyond what the policy says, because sometimes the policies are just directional to procuring entities that say the procurement must have a clause with regard to unfair advantage and conflict of interest that covers these points. The procurement document itself may flesh those out, and I've often worked with clients in the public sector to define unfair advantage and conflict of interest for the particular procurement that I'm advising to. These two concepts exist under trade agreement and common law. So if your client's bidding on a non-covered, non-trade agreement covered procurement, these concepts exist. And in fact, in the Canadian courts, what they've said about conflict of interest is it doesn't have to be a disqualification criteria that's specifically identified in the procurement document in order for the procuring entity to be entitled to assess for a conflict of interest. They can do that as of right because it's a critical and fundamental important element of maintaining the integrity of a public procurement. As we said, it's becoming more prevalent, so we always do it this way isn't going to continue to be the way that you can manage this going further. Part of this is because public entities are doing a lot more outsourcing. So as I've said in the deck, contractors are now kind of having to pick up in their activities some of the discretion in decision making that the public sector entity may have formerly made. So they need to know that that contractor doesn't have a conflict of interest. Your bidders are going to have to often declare that they don't have an unfair conflict of interest, and then they're not going to do anything that would cause, again, actual potential or perceived unfair advantage or conflict of interest. So they've actually got a declaration that's binding them. And these declarations are often carried through from the procurement process into the contract. So they stay what we call evergreen. And that declaration never dies. It just carries along with the contractor. And again, it's an issue for your client, but it's also an issue for the procuring entity, because if they see or they perceive an unfair advantage or conflict of interest has arisen, the public sector entity needs to deal with it. They can't ignore it. And if we can just go to the next slide. Andrew, you might want to give a little bit of comment to this if you feel like you'd like to. But this is an example of a regulation at the federal level where we specifically go back to the issue of lobbying. And we're starting to see these type of provisions, particularly in procuring scenarios where lobbying laws are starting to become stricter. We're starting to see that contractors are being required to declare that they haven't, in this case it's dealing with the Federal Lobbyists Act, paid directly or indirectly a contingency fee for the solicitation, negotiation, or obtaining a contract. If the payment of a fee would require the individual to file a return under Section 5. And I'll just pause there, Andrew. I don't know if you want to offer up any comment with regard to this issue.
Yeah, thanks, Marcia. I mean, this is interesting because you have embedded in a specific procurement rule an incorporation by reference to the Lobbying Act itself. And this sort of illustrates one of these crossovers whereby procurement authorities are deeply aware of the operation of the lobbying regime and actually cite with specificity Section 5, which governs, of course, the conduct of consultant lobbyists. So for those, and I don't suggest that there are many on the line, but for those who have said no, these are completely separate regimes and separate bodies of rules. No, they run in parallel. They intersect, and each of the authorities, the lobbying and procurement authorities, are aware of each other. And certainly in this case, there's a direct link from the procurement world into the lobbying world through Section 5 and the governance of consultant lobbyists.
Thank you. And I would also say that even if the lobbying legislation for the jurisdiction that your client is, submitting a bid within, even if the procurement document doesn't cross-reference back to lobbying legislation, the legislation still applies. So there's still that particular issue, and being aware of what are the controls on lobbying vis-a-vis procurement under the lobbying legislation as well. Okay, so all this great news. So now let's move to the next slide. So finally, the contract's been awarded. Now you're probably back within the realm of being able to lobby again, because the communication rules that we've talked about apply to the solicitation period. They apply to the bidders, and they apply to those who represent the bidders, and they apply. And now we've got a contract award. So the question is lobbying the answer? And in my view, I think it's an incomplete answer. And the reason why is because if your client has won, probably your lobbying focus will be a little bit different. You may shift off to lobbying on a different issue, or you're dealing, maybe there's some other issue that you want to deal with. But oftentimes what we end up with in our office is a client who's been unsuccessful, and they want to know how to deal with the bid. What I always explain to the client is, if the procurement has been run appropriately and a contract has been awarded, lobbying alone will not overturn that contract. The bidder is required to dispute the contract award in a formal setting. They're required to bring evidence that would explain why this contract should not have been awarded, and they would need to be able to justify a claim that the contract has not been awarded appropriately. The other thing to remember, and this is often something that we see, is if your client as the bidder has not understood the procurement and the requirements, and they submitted a bid that wasn't responsive to the tender, lobbying can't overcome that either. Because again, under trade agreement and the common law in Canada, it's always up to the bidder to know what the bid says, to know what the bid requirements are, and to submit a responsive bid. What we always recommend clients do, of course, is if you have not been successful, get your debrief immediately. The debrief will only deal with the evaluation of your client's bid. They won't give you copies of, for example, the evaluation of other, the winning bidder. but your client needs to get into the debrief scenario, get the information that they need to figure out, did I lose fair and square, or do I have another issue? The other thing, as we mentioned earlier, is things are changing. We're seeing a lot more increasing confidentiality obligations on bidders with regard to bid disputes and with regard to information sharing, even for successful bidders. So they will need to be cognizant of, if there were confidentiality provisions in the tender process, are they following them into the debrief, or how can we deal with the information that we receive in a debrief? While there could be an element of lobbying involved with that information, you have to be very, very cautious. And we'll go to the next slide in a minute and we'll talk about that. But thanks, Lauren. But the issue there is, if you're a Canadian bidder, unfortunately, we do not have a great we have a bid dispute system in Canada. We have the Canadian International Trade Tribunal, but that's only for procurements covered by trade agreements. Otherwise, if you don't have access to that tribunal, in any other scenario, your client is looking at an internal bid dispute solution that the procuring entity's organization may provide, or they're looking at a legal action. For the 4 Western provinces, they do have a bid dispute mechanism, but again, it's for the 4 Western provinces, and it's with regard to trade covered procurement. So your client's ability to be able to overturn, as I say, a contract award, absent evidence of why it should be overturned, gets very difficult to argue from a pure lobbying perspective. Again, if a procuring entity has conducted themselves appropriately, their risk profile in overturning a contract that's been awarded appropriately is just too high. It doesn't make any sense for them to consider that. And this is why ultimately, when we're working with our clients, the proactive effort is at the front end of this process, getting to the industry days, getting to deal with requirements. When you're in the bidding process, asking the questions about the procurement to the contracting authority, setting the groundwork for questions later, gathering up your evidence of, if later it becomes apparent that the provisions of the bid were unclear and nobody really understood them. If your client has been well placed and has been asking questions back and forth to the contracting authority, that's an incredibly important body of evidence for the client to have if they want to move forward and dispute the award. So now let's go on over to the communications matrix. And Andrew, you and I will come back in and have a chat about this. This is kind of like a visual of considerations with regard to kind of summing up what we talked about earlier. But as we also mentioned at the beginning, each lobbying activity and the time frame within which you're considering lobbying or taking other actions has to be evaluated on a case-by-case basis. Again, we've got trade agreements, we've got common law, we've got available policies and directives that might be publicly available, but we've also got to consider, again, looking at what does the procurement document say about communication. And at that, I'll pause, Andrew, if you wanted to comment on our grid.
We'll come off mute. Thanks, Marcia, for walking us through all of that. And let me just make a couple of comments before we get into the matrix here, in terms of some things that Marcia has said, because for some of you, you're hearing this and it is either very new to you, very foreign, or very troublesome. And in the spirit of empathy, as someone who occasionally lobbies, Marcia, one of the things that was listed in your slides, communicating with any person with a view to influencing preferred treatment, is problematic. For many of us, we look at those words and say, I'm pretty sure that's the name of the game. That's what I do when I lobby. I communicate with people with a view to influencing preferred treatment for my client. And I'm now hearing that's very problematic under procurement rules. And this is where, as we talk about this communications matrix, hopefully we can paint a little bit of a roadmap. I don't know how else to say this. We don't write the laws. Well, Marcia, you may have taken a hand in writing some of these when you were in government. But we do want to make sure that we get this fairly and squarely on the table for you, and do what we can to help you ask those important questions when you're in the midst of communicating in relation to a procurement, and to navigate them safely. This may also be a good time to give a thought to the officials who have to navigate this stuff from inside government, and how difficult all of this is for a procurement authority. They are, on the one hand, told, do it quick, do it very effectively. Get us the stuff we need to keep our men and women in uniform safe. Get us the technology that our officials need. So do it all fast, do it correctly in terms of the effectiveness, but also do it very, very fairly. Make sure that this procurement is unassailable in terms of its fair conduct. And these are, I'm sorry, very competing values. You can't do anything terribly quickly, but also extremely fairly. Those are competing values, to be sure. And finally, Marcia, I took note of one of the two basic rules: communicate only to the procurement authority. And if you violate that rule, the absolute right to remove a bidder, you might get one of those alert letters, a letter of caution about communicating outside that sanctity of the procurement process. And of course, for many of those who are listening right now, that again is in their view the bread and butter of lobbying. Yes, you have the procurement, but you're conducting activities outside that procurement in support of the procurement. And we're just going to, in the next couple of minutes, look at some of the consequences of this as we come into this procurement communications matrix. It's fair to observe it would be impossible to lay out every permutation, every scenario related to procurement as it intersects with lobbying and vice versa. What we've tried to do here is to provide a basic roadmap and just a reminder of the basic rules and their application. So you can see that you have in the far left column, on whose behalf are you communicating? Is it on behalf of your employer, which would make you an in-house lobbyist, or is it on behalf of a client, which would make you a consultant lobbyist? And as you come across that row, you see those temporal sections or moments in a procurement. Pre-procurement process, this is where I think there's, for many of you as consultant lobbyists, this is the moment where you are impacting the procurement before it ever begins, which is to shape the government's understanding of what it needs. And we all know this is an important thing, helping the government to understand what technologies are available, what challenges are in the marketplace, what the marketplace can validly deliver. There's so much room here for valid legal lobbying efforts, provided you are duly registered. For in-house lobbyists, people who work for a corporation, who have an employer, you are still lobbying, but you have famously that 20% rule that so many people rely upon. And of course, be careful in the calculation of the 20% rule. That's 20% of the lobbying efforts across a corporation, and it's calculated on a monthly basis. As you move forward in time through the procurement process, if you are in-house, as many of you are, as long as you're communicating to the contract authority, you're not lobbying because you are within a procurement process. If you're communicating to others, and here's where it gets quite murky. Let's say you're an in-house lobbyist, you work for a corporation that is selling its own goods or services, but you decide it is important for whatever reason to speak to the deputy minister or speak to the minister or minister's staff. You are at that point outside the sanctity of the procurement process. If your purpose is simply to support the sale of your goods, then you are very likely not lobbying under the Lobbying Act. If, on the other hand, your purpose is to somehow fundamentally change the procurement because you believe it's flawed, have another bidder removed from the process because you believe their product is flawed in some way, you may at that point not be selling, but instead you may be trying to change the policy, the underpinnings of that procurement. And that very likely is lobbying. And this is why Marcia mentioned that these things must be judged on a case-by-case basis. Marcia, I'll pause there and see what you would add on these points.
Sure. One thing I would note is when the issue of with regard to change of policy, one question I would have for you, Andrew, is, sometimes one might consider policy means there's a formal written policy with regard to a certain decision process of the procuring entity. It's not just that, though, if I've understood you correctly. It's if you are trying to change the air quotes policy of the procurement itself, and policy maybe in that case the concept is interpreted more broadly, which is you're trying to have a public official change the requirements of a procurement to the benefit of your client. It's not, you may not kind of see that as a formally defined quote policy, but would that be the same kind of consideration as the quote policy related issue?
Well, let me unpack this with perhaps an example that may be relevant to those who work in technology. Purely from a theoretical perspective, maybe the government thinks it wants to buy server-based storage technology, and in fact, you happen to know that. Look, come on, everything has moved to cloud. We're talking about cloud, and you go to the government to say, look, you're trying to buy the wrong thing. No offense intended. But what you're doing here, what you're asking the marketplace to provide is just the wrong thing. Well, you're not only trying to sell your goods and services. What you're trying to do there is fundamentally change the nature of the procurement itself. That, in my view, is a policy change. And that, subject to the 20% rule when you are in-house, would be lobbying. It's no longer simple sales, it's a change to policy. Marcia, I don't know if that fully addressed your question, and I guess I'd throw one back to you. We've only talked about, in that particular cell of the procurement matrix, we've talked about for in-house lobbyists, whether they are communicating in support of sales or whether they're trying to change policy. But you'll see that but, and it's a big but, it's underlined, may still violate procurement rules. Why is it we chose to include this in the chart when we've said if you're in-house and you're just trying to sell, you're probably not even lobbying? Are you still in trouble if you do that?
And again, that goes back to the reason why it says but may, which is, as lawyers, we never seem to ever want to be definitive. But the reason why it's in the but may format is because, in my mind, again, what we need to be clear on is what are the procurement rules of that procurement. If it is clear, for example, that as some of the examples I gave earlier, the bidder communicates in writing to the contract authority authority provides a response to that question to every bidder. If that's your rule of communications, then the minute you step outside of the communications with the contracting authority, you're violating the procurement rules, and you're probably triggering the procuring authority's reserved right to consider removing you as a bidder if you're in-house and you're doing it. So you're also representing yourself as the bidder. So that's why it's the but may. Again, if you're dealing with the contracting authority, I have never seen in all the time I've been doing this, a procurement rule that would say, even if you communicate with the contracting authority as the bidder, you're in violation. Although I could put an asterisk on that and say, if the requirement is you communicate in writing and you keep on phoning the procurement authority and asking questions, and they keep on asking you, could you please put that in writing? I need to share this. Then you're starting to actually, even in that case, move yourself outside the procurement rules. But I can tell you from my time working with the government, definitely it was almost saving people from themselves when people, either a consultant lobbyist or an in-house lobbyist, started to try and contact senior public officials with regard to the procurement and it being underway. We would receive an inquiry from the deputy minister's office or the minister's office that would say what's going on in the procurement, and the advice we would always send back to the minister or the deputy minister or whomever was asking was, we're in the middle of a live procurement. Could you kindly ask the bidder to communicate directly with the contracting authority? So again, unless it's an egregious offense, I would be surprised if any procuring authority would automatically want to remove a bidder for a one-time failure to comply with the rules, particularly in those types of procurements where you have a small set of bidders. You don't want to start booting people out unnecessarily, but keeping in mind that whatever your rules are on communication, even if you're dealing with the contracting authority and it's supposed to be in writing and you keep on calling them, that's also an issue that you need to consider. So does that answer your question?
I think it does, and thank you to those who are sending in questions. We're tracking these, and we'll loop back to as many of them as we can.
Oh, sure, yeah. Marcia,
I want to take you back for a moment to the example that I opened with the GPS ankle bracelets. I took calls from industry members. Those industry members were able to educate me on the state of the art of GPS technology. Which allowed me to ask sensible questions of our deputy, who then was able to ask sensible questions of the agency in question. And it really, it had the effect of putting a full pause on that particular procurement. Like everyone said, stop, this is broken. We can't go forward on this basis. We're in the process of buying like 10 or 15-year-old technology that is not only out of date, but potentially dangerous, given the fact we're trying to track with precision the physical location of offenders. And for those offenders, it really mattered to their right of fair treatment. If they're not at the kids' playground, and in fact, they were respecting curfew in their apartment half a kilometer away, well, gosh, that really matters. And so, I would say that candidly, people who called me probably broke the rules, the communication rules. In taking the call, I probably broke the communication rules. In speaking with the deputy and then his onward inquiries of the procuring authority, all of this was breaking of the rules, but it resulted, I would argue, in a good outcome. And I think there's probably folks watching who would say, yeah, I've been in this situation. My clients have been in this situation where someone had to speak out. There was a public policy value at play. Not only a commercial value, but a public policy value. How do you weigh and measure these things? And is it correct for me to say to you, there are potential penalties? You could be booted out of a procurement for speaking up, because that's what the rules say. But it's not necessarily true that you will be booted out. Is that a fair statement?
That's a fair statement. And one of the elements that you raised in your example is sometimes things go off the rails unintentionally. And in the public sector, particularly in complex procurements, you start with your requirements, and by the time all the approvals have been obtained and the requirements have been written and there's been, budget has been allocated, the next thing you know, you're in a scenario as you described, which is, I now have my requirements, they're woefully out of date, and now I've got to hit the ground running with a procurement. In that case, I think that's, again, the risk analysis balance that you do with your client, that you look at what the issue is. And it may be that your client says, look, I'm not going to bid if these are the requirements because this is old technology, and in good faith, I can't submit a bid to supply something that is not going to work, that isn't the best offering that I could offer the client. In those cases, if your client says, look, I'm not going to bid anyway, I just want to get to the root of this issue, I want to identify that we've got an issue with requirements and it's in the public interest to do so, then that's an entirely different risk analysis. And that's one that, you may look and say, look, dealing with the contracting authority is not getting me anywhere, because they're in their world. They've been told, get the procurement done. They've got the requirements. They can't change what they're doing, and they're unable to terminate the procurement. So if they can't terminate the process, everyone's just stuck. Like I said, some things have gone off the rails. So in that case, it may be that a targeted lobbying effort, well thought out, where the client understands what the risks are, and you're able to marshal the evidence that explains why this procurement needs to be paused or terminated and restarted, would be probably very much advisable, because otherwise you've got an issue that's almost untenable as far as, the spending of public funds to acquire technologies that just are so out of date, they're unsafe. Again, that's where, as I keep on saying today, as I always say to my clients, getting into the requirements at the front end, when those requirements were being defined, and having access to that and using all the available communication tools at your disposal to try and deal with those requirements at the outset is incredibly important. And you may be able to do that before you get into a procurement process where you can still lobby effectively.
So if we turn for a moment to the bottom row, which is applicable to consultant lobbyists, you see how the analysis becomes very, very simple. You across the board, as you meet those requirements for the definition of lobbying, you're being paid, you're communicating on a registrable topic to a public office holder, you're lobbying. And this is not a shock to any of you. The only thing I'd like to illustrate here is that if your client is within the lobbying process, this is that third column during the procurement process, you are not only potentially in violation of the procurement rules on behalf of your client, but because you are registered to lobby, and if you're speaking to senior people in government, namely those designated public office holders, you're also giving direct evidence of the fact, in public-facing evidence in the form of the lobbyist registry, of that violation of the procurement rules. And many of you can see the problem with that. An in-house lobbyist can at least do this if they're within the 20% rule more quietly. Now, how quietly? Not very, because you're speaking to government, but at least it is not landing in most cases in the registry of lobbyists. And so, my advice here, or I guess it would be an observation, because advice would have to be very much predicated on specific fact patterns. It is consider with your client very carefully, do the conditions for an intervention outside the procurement authority exist? Do they really exist? Or are you just frustrated by how things are going? Those are two very different scenarios. And this is where, and this will sound self-serving, but I'm going to do it anyway, speak to someone like Marcia Mills. First and foremost, we are considering a lobbying push into the DM's office or the minister's office or to the prime minister's office on this procurement, because we think it is so fundamentally broken. Do this with great caution, do it with your eyes open. And I would go further, and Marcia will reemphasize this at the end. I would do it in writing. Make sure you have a written instruction from your client that says, we're going to take this risk. We've weighed and measured the risk, and we're going to go for it together. That, I think, is a professional way of doing this, given the stakes and given the level of game in which you are involved and the consequences thereof. Marcia, is there anything else you'd like to highlight in this table?
Yeah, I will highlight one more thing, and I do want to leave. We've got time. We'll have time for questions. But one of the issues I also wanted to identify is where we're saying in each of these columns, consider impact on litigation strategy. The reason why I mention that is because if, for example, you've got a trade-covered procurement, if you want to dispute the contract award or you want to dispute that your client has been disqualified, you need evidence at the Canadian International Trade Tribunal. The tribunal is very clear that you cannot just come to the tribunal and say, I wasn't treated nicely and it was biased against me. The tribunal says, yes, fine, but I need evidence of that. So you do need to justify. And as Andrew said, yes, you may be taking a different tact. You may be working outside of the procurement communication rules because you want to get information into senior bureaucrats, senior public office holders, but your client also has to be aware that they need to be communicating the issues with the procurement in writing to the contracting authority to receive a response from the contracting authority in order to marshal that evidence if in future, if they're unsuccessful, they want to look at a dispute resolution mechanism. Because again, the tribunal is the same as the courts. The courts will not just accept blanket claims of being treated unfairly or being prejudiced against, or that the procurement was biased. Your client needs to marshal the evidence, and the way that they do that is through communications during the procurement process back and forth with the contracting authority about the RFP itself. The other issue, of course, to keep in mind, and again, why Andrew said consult with external counsel on this, is to the extent you're disclosing issues with regard to your client's products or services, or with regard to your client, you're now perhaps, again, giving evidence against yourself with respect to why your client wanted the procurement set aside or wanted things changed. So you always need to be incredibly diligent and careful about the information that you're communicating when we're talking about a procurement process, because the procurement process has its own rules, and the dispute of the outcome of that process for your client is a legal-based approach. They're either disputing with the contracting authority at the trade tribunal, if it's a trade cover procurement at the federal level, or within the legal system. And all of those require evidence to be brought forward.
Okay, Marcia, if you agree, we'll move forward to the next slide, which I believe is our takeaways section, and then we'll move to questions.
Slide. There we go. Sure. And this is the slide also known as, if I got nothing else out of today, what should I have gotten out of today? So always determine, have I got an active procurement underway? Am I falling into a rule scope? If I am, what are those rules? What can my client do? What can I do? Can I be strategic? Can I deal with these rules? Who needs to submit communications? Always keep in mind what certifications your client is required to give and what declarations with regard to compliance with the rules of the procurement, with regard to unfair advantage, with regard to conflict of interest. Do you know if what you're about to do in your communications is okay, or it places your client in breach? And then, as Andrew has said, as I would strongly agree, does your client understand that they bear all the risk of non-compliance? As a lobbyist, if you lobby and your client is removed from the procurement, that is detrimental to your relationship with your client. But what's incredibly detrimental to your client is they're now out. And as Andrew said, does the client understand that? Has it been communicated to them in writing? The sixth point is when Andrew speaks better to this than I do, but am I poisoning the well? So by lobbying, by continuing to raise issues outside of the communication rules, am I starting to create an environment where my client is having difficulty with the contracting authority in general? So for example, if it comes to one of those very precise decisions where it can go one way or the other for your client, and your contracting authority has been incredibly annoyed by all of the lobbying that you've been doing and all of the outside communications that you've been doing, and has advised you to stop, and has not terminated your client from the procurement. And so I would always say, don't think just because your client hasn't been warned or hasn't been terminated that the contracting authority isn't still taking note about what's going on in the background, particularly if they keep on getting questions from senior level officials asking about the procurement. They're going to know that somebody is not complying with the rules. They may not know it's you, but they may become quite aware that they've got a bidder that's not paying attention. They may let them continue on in the procurement, but as I say, if it comes down to a decision going one way or the other on a particular issue for the bidder who's doing all of this communication rule violation, it may go to the negative. Finally, again, is there anything you're doing that could prejudice your client's position if they want to move forward into a formal dispute or litigation scenario? And again, at that point, I would say it's worthwhile to get advice of counsel with regard to the type of letters that you're drafting, with regard to the type of information that you're giving to government officials, and with regard to your approach. And at that, Andrew, I think we can go to questions if you're able to lead with those.
I will. I'll just go back for a moment. We're making good time, by the way, and thank you for those to those who've sent in questions. I'll go back to that "Am I poisoning the well?" question for just a moment. Maybe we want to flip back one slide. Item 6. For me, this comes down to: am I advising a client, either within my own organization or corporation, or in a client relationship, where the client will validly say to me, in this particular procurement, if this doesn't get fixed, I don't want to win. And let me use the example that I provided at the outset. Our corporation will not provide to the government of Canada GPS technology that is so flawed that it will invariably become the subject of an Auditor General's report 2 years hence, and various serious allegations of derogation from public safety. If this doesn't get fixed in the procurement itself, then we're not bidding anyway. Well, then you're in a scenario where you're already playing in a poisoned well. You want out unless things are clarified. And that, to me, is a situation ripe for lobbying, because the reward will outweigh the risk. The chance you might get this thing fixed by intervening with the minister's office, the prime minister's office, outweighs the risk of receiving a letter of caution from the procurement authority to say, hey, you're communicating outside the procurement authority. You're not allowed to do that. If you do it again, we will remove you from this procurement process. And maybe your CEO's answer is, fine, great, because I'm done here. Well, that's a well you don't mind avoiding. If you can't say that, and you are heavily invested in a particular procurement process, even though you disagree with some of the technological elements, you feel you're being treated unfairly, but you don't have concrete evidence of that. In that scenario, I think that the risk does indeed outweigh the reward, and you want to be very cautious about your lobbying activities, in-house or through a consultant, that go outside the sanctity of the procurement authority. So hopefully that gives people some guardrails within which to drive as they are approaching these procurement opportunities. And now let's flip over and we'll do some questions. And thanks to those who've sent in some tough but fair questions. And I'll just, Marcia, I think what I'll do is organize these on the basis of most relevant to procurement issues. Let's start with this one. Sometimes an RFP simply asks the bidder for a no conflict of interest certification without a specific definition of conflict of interest or unfair advantage. How would you recommend handling that?
Absolutely. My first recommendation on that would be to submit a question to the contracting authority seeking clarification. There's always, unless we're in an emergency situation, or even then, I would anticipate that the contracting authority always leaves a period of time during the solicitation period for when the RFP is released and when the bid closes. In that intervening period, there's always room to request questions, and usually the contracting authority will take questions up until, say, for example, 5 days before the bid solicitation closes. In that case, particularly in conflict of interest and unfair advantage, I would want to know, how are they defining it? And again, you could look and you may be able to see a directive or a policy that applies to that procurement that says, as I said before, every procurement must have provisions, but it doesn't say what the definitions are. So going back and asking for clarification on those definitions is incredibly important. And identifying that it's difficult, particularly for a corporation, to provide a certification of something they have no definition for is incredibly difficult for corporations.
Now, we've seen situations where a bidder has a question, but the question implies a frailty in the bid itself. The question's a little bit overly revealing. And there's been a real debate about whether we should ask that question or not. What happens to questions? And I think you covered this, but I think it bears re-emphasizing. What happens to a formal question? Well, sorry, is there such thing as an informal question? And if the answer is no, what happens to questions once they're put to the procurement authority?
Sure. And so I'll talk a bit about the trade agreement approach to that, because as I said before, oftentimes that approach will infuse non-trade agreement covered questions. So under trade agreements, all bidders are supposed to have access to all information about the bid. It doesn't say concurrently, but the way that it's being interpreted in public tendering scenarios in Canada is the written Q&A. So the question comes in and then the answer is sent out to everyone. So normally that's the process, putting it in writing. And the issue that you've hit upon is one that I often work with clients on is, I've got a question and how do I submit the question, not disclosing what the frailty is in my product or service. You have to understand that in the normal case, what you'll also see in procurement is a requirement that, all substantive responses relevant to the bid will be shared, or the procuring authority may have a rule that says if you submit a question that contains confidential information, the procuring authority will ask you to resubmit it in a way in which it isn't confidential. And sometimes if you fail to do so, they'll either refuse to answer the question, or they will determine how to answer the question in a way that they don't believe reveals confidential information and still go ahead with the response. So again, this harkens back to the issue of when you get the RFP and if there's an industry, or if for example, you're in a pre-procurement phase and the public entity has put out their requirements and you can have confidential meetings before the procurement starts, those are a great opportunity as well to be able to sit in a room with a public official on a confidential basis and discuss particular issues with your product.
Okay, thank you for that, Marcia. I think that's important to know that you can ask a question, but the question and the answer goes to everyone. Like that's simply how it works, and you can see the basic fairness in that. Marcia, you often refer to the common law, or you have referred to the common law in your presentation. Yeah. Is there any impact with respect to the Quebec civil law? And this may not be a fair question for you. I know you're not a Quebec barrister, but do you happen to know, are there, maybe the answer is yes, are there Quebec Civil Code procurement rules?
There may very well be. However, as you pointed out, I'm not a civilist. But I will say that under the Civil Code, some of the elements that we're starting to deal with at the Supreme Court in recent decisions with regard to honest contracting and honest negotiation and honest communication between parties, the Supreme Court has actually looked to some of the civil concepts in order to inform themselves in their decision making. So we're not becoming a civilist common law, but the courts will actually look at, the civil code to see how this, the duality of our two legal systems, to see how the civil code has dealt with it. But I would say, kind of just off the top, and I'm happy to take a call later from whoever submitted that question, because we do have a great procurement team in our Montreal office that deals with Quebec-based procurement all the time. But there will be probably some additional invoked elements of fairness and transparency in the civil code that are equivalent to or even more strict than the trade agreement provisions that apply across Canada and also infuse the common law.
Okay, next question. Regarding questions or information that bidders feel compelled to share with a client, suggesting that the procurement is flawed, if bidders are doubtful that their feedback will make it to senior authorities, what are concrete actions that you recommend to bidders that avoids being in a conflict of interest?
Right. So here's the thing about that. During the procurement process, and I'll speak from my federal perspective. So during the procurement process, one of the ways in which the integrity of a procurement is maintained is that the question and answers and how that procurement is managed stays in the procurement team. So if if there's a desire to share information, you've shared it with the procurement authority, you've identified to them, you think it's an unfair procurement, you think it's, and you believe that there are either nefarious actors afoot, or there's just a misunderstanding of what industry can deliver, or as we talked about earlier, the requirements are so out of date, it's impossible to meet them. Again, that's a scenario where you're going to do your risk analysis as a lobbyist, either in-house or consultant, and you're going to decide, and having no success within the procurement group, because as I said, that's usually where you manage the procurement, because you don't want political interference coming in, and you need to be able to run your procurement within the rules of the procurement. That's when you do your risk analysis to decide, look, I need to communicate this information, because when you send it to the contracting authority, depending on what's it's about they have perhaps not necessarily a concrete obligation to keep notifying senior management about what's going on. So I've worked on procurements where we've had hundreds and hundreds of questions. So of course we're not going to start giving reports to senior government officials about, question 492 and question 506 dealt with X, Y, Z. So it may be worthwhile to consider that the questions and the issues that you're raising are staying within the procurement team, and they're not outside of that team, and they're not being shared up just because of the rules, the internal approach to maintaining the integrity of that procurement and the cleanness of the procurement. Because once you've put out your requirements in your bid, bidders are supposed to be responding to those requirements. And as the procurement authority, you're supposed to be able to answer those questions. So again, I'm getting a little long-winded on repeating myself, but that is one of the times when analyzing, okay, I think I've got an issue. How do I communicate this? What's the best approach? Really important to sit down and have that discussion and consider the risks of going outside of the communication rule.
Okay, here's a really interesting question. Would you characterize communication with a public office holder with respect to your own goods and services affecting broader public policy problematic, especially if that communication may result in policy change or an RFP that your organization would bid for in the procurement process? I'll paraphrase that, Marcia, and I'm this is somewhat tongue-in-cheek, but if you're simply promoting your goods and their quality to the government of Canada, and your service offering happens to be so awesome that the government says, oh dear, our procurement is fundamentally flawed. We didn't even know the marketplace could produce this kind of product. Yeah, that's kind of funny, but it has happened. I've seen this where a procurement was impacted simply through knowledge of what was available. And in fact, sort of sounds like a good outcome. But the intent, as I understand this question, was not to lobby on policy. The effect, however, was to change policy. I guess it's a mixed question of procurement and lobbying law, but I'll let you take first stab. What do you think of that?
Sure. Now, the way I understood that question was we may be submitting that information outside of a live procurement. And if that's the case, then that's lobbying, but you don't have a procurement related issue. And, selling your goods and wares to the government is indeed what you would be trying to do at that point. Again, if you're in the middle of a live procurement, I think we're going back to first principles, which is if your client is in the middle of a procurement, or not, if your client isn't participating in a procurement because they think their goods are incredibly much better than what's being asked for, your client could be lobbying, but the advice they will probably receive is, we're in the middle of a procurement, and this is lobbying, still trying to sway the outcome of the procurement. Again, if you're trying to get that RFP, if it's live, if you're trying to get it canceled, again, you have all those considerations with lobbying. The other thing I would note is if your client doesn't bid on that procurement and a contract is awarded, your client has no basis for bringing a complaint to the Canadian International Trade Tribunal or for raising a claim for judicial review or legal action in the court because they didn't participate in the procurement. So I thought I would also mention that as well. The other thing I'll mention is with regard to trade agreements, if you're lobbying on the interest that's one issue. But if your client has been engaged to develop the requirements for an eventual procurement, your client will have issues being able to bid on that procurement in the outcome if they've developed the requirements for that procurement, because that creates a conflict of interest, and the trade agreements speak to that one specifically.
So I think I'll simply follow that up, Marcia, by saying that if, in a lobbying sense, if you are simply promoting the value and bona fides of your product, and you're not asking the government in any way to change its procurement, but in the promotion of your product for sales purposes, the government has an epiphany or a revelation that they've asked the marketplace for far too little, and it ends up changing the procurement. I don't think there you are lobbying. I think you were selling, and it had the very fortuitous impact of causing the government to change course. That probably doesn't happen very often, but I leave open the possibility that it could.
The one thing I will add in is if you're lobbying outside of a procurement, your fantastic news and the epiphany that you've given the government will not be used to change the requirements of a live procurement, because that would be interference. So,
okay, so that's interesting. So that maybe not a lobbying problem, but potentially a procurement law problem.
Yes, exactly. Because if if an office holder had the epiphany, called up the contracting authority and said, "Look, I need you to change the requirements." Now, that's interference, and that's an issue, because now they're being changed, not because the government went out and actually conducted a bona fides requirements assessment, but because the government has been lobbied to do so. And that would be the argument that I would raise were one of my clients a bidder in that procurement, and suddenly we received an amendment to the tender that said, oh, and by the way, these 15 other technical requirements are now in play. I would have a particular issue, because now the entity that's been lobbying can now come in and bid, because they've changed. Yeah. So I think there's a whole bunch of issues that raise there as to timing, again, of when you're doing this lobbying.
Well, I was just going to say, I think timing is the solution to this. If you are particularly a consultant lobbyist who knows that your client has a technology that is emerging, it's brand new, it is the next thing, it's where the market is going, the phase in advance of procurement really is the time to get that on the table to help shape the government's requirements. And that's a completely legitimate activity, provided you're registered to do so.
Yeah, absolutely.
We are about 3 minutes from conclusion, and there's a couple of questions here that are strictly about the mechanics of lobbying. I think we will hold those offline, because they don't intersect directly with procurement. Marcia, this is sort of an interesting one, and I'll tie this into industry days as well, which are very popular in advance of a procurement. How do the rules apply when suppliers regularly visit customers? So this would be, let's say, defense contractors coming to visit government buyers to provide roadmaps of its products, and this happens upon the invitation of the operational groups within the contracting authorities. I guess first to you, any procurement implications, and is this lobbying? And I'll put that question to myself secondly.
Okay, so again, because public sector, public entities still need to know what's going on in the marketplace. So if they come out to the marketplace and they ask, could you come and present your product to us? Absolutely. They're doing their job. They're trying to determine how to meet the requirements of their end user customers. So being invited to go in and discuss your roadmaps, it may be part, if you're already a contractor, you may have provisions in your contract that talk about, having meetings with regard to roadmaps. But if a public buyer, the contracting authority is just reaching out to industry, inviting me to come in and talk, and there's no live procurement going on, then Andrew, you can talk about the lobbying. The one caution I will raise is when you're having these conversations, be careful of, speak open and freely, but also be cognizant of what information your team's being asked to disclose. And always, If you've got information that's confidential and proprietary, then seek a non-disclosure agreement accordingly.
And I'll simply follow up with the lobbying answer. If you are in-house and this is a sales opportunity or promotion of the sale of products or services, then that is technically not lobbying. The one caution I'd offer is that if you're a consultant lobbyist helping to organize either attendance at an industry day or a demonstration day at the company, be aware that even the simple arrangement of that event is very likely the arranging of a meeting for a third party, and that is registrable conduct. Sorry to those that we will not get to, but I wanted to thank everyone for being here today, particularly under the conditions in which we all labor. I hope this has been a welcome distraction from what is otherwise kind of a bad time in Ontario, at least, and I know in other parts of the country. We hope that you all stay safe and well, and we just wanted to thank you for your time. Reach out to us with any follow-up questions. We are a phone call or a Teams invite away. Our information is on screen. And again, thank you for your time and attention today. All the best.
And if I could just add in, Andrew, we would greatly appreciate people completing the survey at the end. If you found that this was helpful, or if there's another topic you would like us to cover with regard to procurement and or lobbying, by all means, please let us know.
Fantastic. Thanks all. And thanks, Marcia.
Thank you. Thank you, Andrew.